A trademark, basically, is an indication of the origin of your product, be it goods or services, and it can be registered or unregistered. In order to be unregistered, you have to have developed some goodwill in your mark, which can take a matter of years. But registration of your trademark can take a matter of months, although it does, of course, cost money, but after that you have a right on a public register. Basically, any and all types of brands can be amenable to trademark protection. If you're talking about the kind of things, the kind of signs that can be trademarked, as it were, well, we've got words, obviously, can be trademarks. Also, logos or pictures can be trademarks as well. There are things you can't trademark. You can't trademark a smell, for example, because the rule is that to be amenable to trademark protection, the sign has to be amenable to graphical representation. And it's been held that you can't graphically represent a smell, even if you have a chemical structure or a mass spectrometry trace of it. So you can't get trademarks for a smell. But you can, for example, get trademarks for a colour. I think T-Mobile have a certain shade of pink as their registered trademark. You can also get trademarks for a tune or a jingle. Again, T-Mobile's jingle is trademark protected. And you can also get trademarks for a gesture. So T-Mobile have a gesture which I shan't do now, but which is protected by a registered trademark. Well, that's the good thing. Protection can last forever. With a registered trademark, as long as you keep paying the renewal fees, it can last from now until 100 years from now, 200 years from now, whenever. I think the first trademark was applied for, certainly in this country, in 1876, forgive me if I got that wrong, but that was for the Bass Company. And they've kept paying the renewal fees since then, and the trademark is alive to this very day. Well, in terms of what a trademark allows you to do, basically, it gives you a monopoly with respect to use of that mark, or confusingly similar marks, in the class for which it's registered. A very important detail is you have to register trademarks for a certain class or certain classes. Think, for example, of a trademark like Polo. That's registered by the Volkswagen company with respect to at least cars. But it's also a registered trademark for a completely different corporate entity with respect to mints with a whole. So trademarks allow you to stop someone else from using the same or a similar mark with respect to the same goods or services for which they are registered. Goods and services in the same class. That, unfortunately, is the bad news. No one in the government or elsewhere is obliged to inform you that your trademark is being infringed. In fact, usually they won't know and won't care. As a rights holder, it's up to you to keep your eyes open and your metaphorical ear to the ground so you can find out what your competitors are doing and see whether or not they're using marks which are the same as or confusingly similar to yours in the same class for which your trademark is registered. Well, the obvious answer to that is call a lawyer, call either a solicitor or a trademark attorney, and they'll be able to tell you whether or not your right is in fact being infringed, and also give you very clear advice, commercial advice as well as legal advice, regarding what your options are in terms of pursuing the alleged infringer.